Hi, my name is Lacey, and you are listening to the HigherEdReg Rundown. And today's topic specifically is the U.S. Department of Education's new financial responsibility reporting requirements. Thompson Coburn, if you don't know us, is a pretty large law firm. We have offices around the country, and we have a higher education practice, which means we have a group of attorneys who spend all or most of their time serving institutions of higher education. The HigherEdReg Rundown is a series of succinct videos that we started to produce, the design of which is to provide important information on a focused topic. And we want to keep them to 10-15 minutes and really try to pack in what's important so you can digest it and digest it quickly. With that being said, let's get started. So many of you know there is a new set of regulations promulgated by the U.S. Department of Education that is set to become effective this July 1, 2024. This video, by the way, is being made about halfway through June, so we're about 2 weeks out from that effective date. And those regulations cover a wide range of issues. They are complex both in their breadth and their depth. They were promulgated or created via 3 different negotiated rulemakings, and you can see here on your screen we've got the links. And by the way, you can get, if you go, I'll show you in a little bit, the QR code you can scan to get to our Higher Ed resources page, where all of our videos and other materials are located, and also you can find the slides for this presentation. And these links are active links, so that if you click on those, you can actually go to the final rule as it appeared in the Federal Register. But what I wanted to highlight here is that there are a lot of different things that take effect July 1st. You've got these new income-driven repayment plans, which is important for students, less of a concern probably for institutions. You have the financial value transparency and gainful employment rulemaking package, which is very significant to institutions, and we have covered in prior higher ed reg rundowns and CLEs and other videos and materials. And then you have another set of regulations that were promulgated in yet another final rule last fall in the Federal Register that also covers a range of topics that are extremely important to institutions. And some of these, like you'll see certification procedures for Title IV participation, standards of administrative capability, a lot of the topics that we've heard a great deal of discussion around, there is even now some litigation around some of these topics, are sort of packed into those umbrella concepts, certification and standards of administrative capability. And that includes the new requirements regarding professional licensure and professional licensure disclosures, transcript withholding, and standards of administrative capability. They're the new requirements for vetting diplomas where you may have some reason to doubt their validity. So there's all kinds of stuff packed in there, and we've been working with a lot of clients to discuss many of those. But one area where we have not heard as much discussion is the new financial responsibility regulations, and in particular, the requirements that are to become effective July 1 for reporting financial responsibility events or triggering events. So that's what we really wanted to highlight in today's Higher Ed Reg Rundown. That having been said, I thought I would take just a few minutes. I'm not bearing the lead, but I did want to just talk about a few of the other things that are part of this new financial responsibility rulemaking package. For example, there are some changes, and you'll see at the bottom here of the screen, we try to include the citation. So this will be in the 668.23, that's 34 CFR 668.23. That's the section on financial and compliance audits. There's some revisions to that section, which include, for example, for proprietary institutions, some changes to when those audits have to be submitted. Proprietary schools, if you don't know, submit 2 different audits. They have a financial audit and a standalone Title IV compliance audit, where, of course, private nonprofits and public institutions have the single audit that they create. The department is also now requiring for fiscal years beginning on or after July 1, 2024, that the financial statements submitted to the department match the fiscal year end of the entity's annual return filed with the IRS. We have run into some schools that actually did not have those already in sync, and so they're having to take steps to get them into sync. Another thing we wanted to highlight, this is another change that's in 668.23 come July 1. Any institution that's owned directly or indirectly by a foreign entity holding at least a 50% voting or equity interest in the institution is going to have to disclose new information about that foreign entity's ownership interest. There are also changes to the general standards of financial responsibility. Those of you who spend a lot of time in and around financial aid or Title IV certainly are aware that financial responsibility and administrative capability are 2 of the sort of fundamental pillars of Title IV eligibility, and there's a lot that gets baked into those. But if you look at 668.171, that's where the sort of primary core standards of financial responsibility are located at the very beginning of that regulation, and there have long been 4 or 5 different things that an institution has to establish and or avoid to be financially responsible. And come July 1, there are 2 or 3 new things that are being inserted into that sort of core introductory section in 668-171. One of them, for example, is an institution ceases to be financially responsible if it, quote, fails to make a payment in accordance with an existing undisputed financial obligation for more than 90 days. Extremely vague language, quite unclear at present what the department means by that. And I think the community, meaning the regulated community of institutions of higher education, are going to be on the lookout for that and for some additional clarity around what exactly that means. Also, there are new standards regarding payment of payroll obligations and the borrowing of funds from retirement plans or restricted funds without authorization. So be aware that there are some new additions to those core requirements regarding financial responsibility. There's some revision to 668-175, which concerns alternative participation. So this would be anyone who might be participating on provisional certification or in the zone. So if you had a composite score that was less than 1.5 and you're in the zone, or if you went through a merger or some other substantive change or change in ownership, you may be on provisional participation. So the department has changed, if you are in one of those alternative participation modes, changed exactly what you have to do to establish that you are financially responsible. And most significantly, the department has indicated that once you are in one of those alternative participation modes, then the department has to be fully satisfied that whatever put you there has been resolved before they will let you off. And if you look across the changes to these regulations, and we appreciate most people have not done that because you have schools to run and operate, but if you were, you would see that a lot of the changes are designed to give the department more flexibility in putting schools into provisional certification or into the zone, requiring letters of credit, things like that, and also giving the department more flexibility in keeping schools in those alternative participation modes. And that's part of what this is about, is that overall revision of the regulations across many different sections. The other thing is, if you are an institution out there that is either considering merging with or acquiring another institution, or if you are considering merging into another institution, we know there's a real increase in transactional activity right now. The department has included a new section in the regulations, or actually I think 668-176 already exists. Right now I believe it's just a couple of lines about severability, but they're going to rewrite that section, and it's going to become a new section that deals with financial responsibility following a change in ownership, and specifically what an institution has to establish following a change in ownership to show that it is financially responsible. And the most important thing I'll highlight here, which really is consequential given the uptick in transactions that involve institutions that are experiencing some sort of financial distress, is that for the first time on the other side of July 1, the department is actually going to evaluate the last 2 years of audited financials by the selling institution, meaning the institution that's being acquired or merging into a larger entity. And if those last 2 years audited financials don't satisfy certain tests, then the new enterprise on the other side of a change in ownership may be required to post a letter of credit. So what this means is, if you are a large institution and you're contemplating picking up the assets of a smaller school and they're going to merge into you and you're going to sort of take over and preserve their legacy, etc., very positive, the kind of thing we want to see out there right now. You also need to be aware that there is a possibility you might have to pay some level of letter of credit or post a letter of credit to the department following the transaction, due to the fact that the institution that you're taking on or acquiring, its financials may not have been that strong over the last 2 fiscal years. The last thing I'll note is under the new rule, the department has some discretion to evaluate transactions and the amount of debt that's being placed on transactions, given the way they're structured, and also some additional flexibility regarding whether or not it might require a letter of credit in that case. But the most important thing, so like I said, I was burying the lead a little bit, but now let's get to it, right? I'm just a few minutes in. The most important thing that we really wanted to highlight, folks, is the significant and meaningful revisions to the financial responsibility reporting framework. Now, some of you may recall that the Obama administration introduced this framework, and it involves sort of this concept of these mandatory triggers and these discretionary triggering events. And the notion is these are events that would occur between your financial audit or single audit submissions, and when they occur, because the department is concerned, they may signal some sort of financial concern that you need to report it to the department so it can determine whether or not that event is material. The Obama administration had a fairly large grouping of mandatory and discretionary triggering events, and their sort of philosophical outlook was, we want to understand if something significant has happened or might happen. So if the triggering event in their view might represent risk, even if that risk hasn't actually occurred or sort of come to fruition. The Trump administration did not throw this framework out entirely. They kept it, but they winnowed it down, and their sort of philosophical view was, well, we want to know about events if and when there's actually some sort of monetary liability that's occurred by the institution. So the Obama administration, you may recall, said, we want to know if somebody files a lawsuit, for example. The Trump administration said, we don't want to know if they file the lawsuit, but if there is a final judgment or settlement, we want to know then because we want to see if it was material to your financial wherewithal, right? But significant to note that the Trump administration did not throw this out entirely. This administration, as we might have expected, has sort of gone back to something that looks more like what the Obama administration rolled out, and they have significantly expanded the number and nature of both mandatory and discretionary triggering events that have to be reported. They've also streamlined the process, and by that I mean they've taken out a little of the due process that was afforded institutions under the prior framework, so that it is now easier for the department to take the steps from the reporting of a triggering event to requiring a potential letter of credit. Essentially covered all this, talking about mandatory and discretionary there in the comments that were just made. The mandatory triggers, I mentioned that they've been expanded, and you can see here on your screen, there are things that you would expect, like monetary judgments, settlements. There's some obligation to report lawsuits, federal or state agency lawsuits, but there are also new additions, like if the department has a BDR recoupment action that is material, if you have a significant number of gainful employment programs that are failing and that impacts your bottom line. And also, there's some requirements around adverse creditor events, and I'm going to talk more about creditor agreements in a second here. But similarly, there's a significantly expanded grouping of discretionary triggers. Some of these, again, you might expect accrediting agency and government agency actions, but some you might not expect, like the closure of an institution or high annual dropout rates. And we don't even know what that means yet. Like the department that was in the Obama administration's rule, it got taken out by the Trump administration. It's coming back. And we still don't even know how the department's going to calculate those and what a high rate or threshold what the threshold might be. The thing I really want to focus you on today, though, and I encourage you strongly to look at, is the new requirements around adverse creditor events, and specifically, most importantly, creditor agreement provisions relating to departmental actions. So there is an obligation in the new rule. There's a discretionary trigger, and the mere presence of a clause in an agreement between an institution and a creditor, and this could involve, implicate bond financing agreements, certainly traditional loan or banking agreements, all those agreements, if you have a clause that basically says it's an event of default if the department takes a certain kind of action. So if the department puts us on HCM 1 or HCM 2, that would be an event of default. The department is taking the view that this in and of itself is a discretionary trigger. Let me take a step back. They're not just taking that view. It's going to be in the regulation as of July 1. And institutions are going to have to really consider the extent to which, they're going to evaluate their credit agreements. They're going to think about whether they believe they may have a reporting obligation and then how they're going to go about reporting. But I strongly encourage counsel to review your credit agreements. If you are in the financial aid office or someone else at an institution who's watching this video who doesn't really deal with those types of relationships, I encourage you to point this video or the guide I'm about to show you to your CFO or your general counsel again, so they can be thoughtful about these new requirements and the nature of their agreements with various creditors, lenders, etc. So I'm not going through all of the new mandatory and discretionary triggers in detail here because this is supposed to be a concise video, but what I am going to let you know is we have updated our financial responsibility reporting guide. We put one out when the in 2020 after the Trump administration. Their version of this came out. We've expanded it now to cover the expanded version that's being put into place July 1. If you scan this QR code right here, it will take you to our higher education resources page, and you can get this document. It's 10, 12 pages, and it has a table, and it sets out the mandatory trigger and the discretionary trigger, and then it also talks about the timetables within which those things have to be reported. So I strongly encourage you to please download this, or even if you don't want to download our guide for whatever reason, look at the regulation directly, reach out to your CFO and your general counsel and make sure you're talking with them, particularly about these creditor agreement reporting obligations. And then more generally, just look at all of these new mandatory and discretionary trigger obligations, because there's a lot there. And again, we have not heard as much discussion around this aspect of all the rules that are becoming effective July 1. I also want to highlight for you that on May 17th, 2024, the department launched a QA website that includes some feedback regarding these financial responsibility reporting requirements. We strongly encourage institutions to review this Q&A, and also we think you will see that some of the positions the department takes in the Q&A don't seem to flow or be entirely consistent with the regulatory language. So you're going to need to talk about those changes and the extent to which the department may seem to be taking an expanded view and wanting you to report even more. And I think you're going to have to talk with your counsel in-house or outside counsel about what you're going to do with that and how you may go about reporting or not reporting, depending on whether you're going to sort of take the position that you're going to stick with the regulation or you're going to go ahead and take into account everything that the staff had said in response to some of these questions when considering your reporting obligations. So again, take a very good look at the regulation, check out our reporting guide, and then please review that guidance as well. With regard to events predating the new rule, the department observes in the Q&A that triggering events in existence on July 1st, 2024 and not considered reportable prior to that date, but considered reportable under the new 2024 rule must be reported by the institution by July 22nd. So in other words, the department's view is if you had a triggering event that occurred prior to July 1 and it's covered under the new rule, you need to report it within 21 days. You can't just say that it predated the rule and you have no reporting obligation. Significantly, again, this guidance also talks about those creditor agreement provisions, and it is in that area in particular that it appears to us that the department has sort of, I'll say, departed from, or at least taken a much wider and expansive view even than what the regulatory language requires. And again, you need to talk with your counsel about that and how you're going to handle it. The other thing I want to mention, if you're watching this and you're a public institution, on this Q&A page and also in the new regulation, but quite expressly on the Q&A page, the department makes clear that public institutions of higher education are covered by these reporting requirements. And not only that, but if you have a triggering event, that you can still be deemed to be not financially responsible and required to post a letter of credit, even if you are backed by the state and you are a state that's a community college or a state flagship institution, you're still covered by these reporting requirements and you can still have your financial responsibility implicated. I know sometimes there is some confusion here because financial responsibility applies to public institutions a little bit differently, but please be aware that the department has very expressly stated that this framework and all these reporting obligations apply to public institutions. And not only that, but notwithstanding that you are backed by the state, you can still be found to lack financial responsibility as a consequence of these reported events if they are deemed to be material. Let's see. Again, I want to just highlight, we have this higher ed resources page. The QR code is right there. And if you scan that QR code, you'll find not only our guide, this new financial responsibility reporting guide, you'll also find our gainful employment guide that we put out, and a number of other webinar, white papers, things that we have tried to create for the higher education community, just to try to be as helpful as we can. I want to make one more note, please. If you are going to be at NACUA, I also wanted to know, this is the second week of June, again, when we're recording this. It's at the very end of the month is the NACUA annual conference this year in Columbus, Ohio. If you're going to be there, we are hosting an event on the half day where activities sort of stop halfway through the day. I believe it's Thursday, and it's right after everything lets out at a local brewery / winery. So if you are interested, please look for that information. Give me a call. We would love for you to come out and hang out with us. And with that, I'll just finally say, please keep in mind that I'm not your attorney and this is not legal advice. It's just information that hopefully will help you be aware of some important topics. Thank you for all you do for supporting higher education and in the United States and your students specifically. We hope you are all well. And if you're going to be at NACUA, please look us up and come out to our event during the annual conference in Columbus, Ohio. Thanks, everybody. See you next time.